I'm now joined by Bouchier, that's an associate attorney at Eversheds Sutherland, to discuss some of the merits of this law. Very good afternoon to you, Dylan. Thank you for joining us. Mixed reviews about this law, understandably so. But let's perhaps start with, the constitutional significance of this law.
Thank you so much for having me. I think it's important to start at the point of stating that the sections of the Constitution itself, which were relevant to this case, were Section 9, which is the right to equality, and Section 10, which is the right to dignity. And really that's where it falls, is the matter of equality. And I think it's just important to give a brief background of the family dynamic that it essentially raised the issues that are at the heart of this case. So what really happened here was that we have Mr. and Mrs. Van Wyk, and during Mrs. Van Wyk's pregnancy, Mr. Van Wyk, who was a salaried employee, he applied for a 4-month maternity leave benefit from the company, but the company refused this. And as a result, he wasn't able to utilize those 4 months. And the reason why he did this was because his spouse was attending to the management of 2 of her businesses, and as a result, she was not able to utilize that 4-month maternity leave period. And so they wanted to utilize it in the most effective way so that her business could be best benefited and they could nurture their newborn baby to the best of their abilities. And so given his refusal of his application for the 4-month maternity leave, he then negotiated an unpaid sabbatical period with his employer, but he wasn't able to claim any of those maternity leave benefits from the Unemployment Insurance Fund, which is the fund that if you pay into, you can make claims from it to pay out for that leave that's unpaid by the employer, as the Basic Conditions of Employment Act doesn't obligate employers to do that. And so the very issue on the heart of the constitutionality issue comes from this, because at the time it was a paternity leave was 10 days, or parental leave as we called it, which is inclusive of the other forms of leave. And the maternity leave was a 4-month period. And so this didn't suit the family dynamic that essentially this family had, and in order to best suit the upbringing of their children. And so they challenged the very constitutionality of those sections, and what we saw was the courts stating that this was it was invalid and needed to be declared that way, and then were offered or at least declared that it would be a 4-month shared maternity leave period, or parental leave period, should we call it. Okay,
let's talk about the family dynamics, particularly when it comes to traditional families where you have a mother and a father, and a mother is naturally expected to give birth to a child. But of course, we live in this modern world where families are not necessarily structured in that way. You can have same-sex parents who are not necessarily biological parents of a child. Does the law speak to that?
So I mean, it does speak to it at the moment. The most recent amendments before this case allowed for commissioning parents, surrogacy parents, in other words, adoption. For example, if you have a same-sex couple that have adopted, those rules were, or at least the law was similar in that sense, in that it afforded a period of time. It was a different periods as the maternity and paternity leave would allow it. So it did allow for that, but it didn't, again, see the issues that needed to be resolved here. And the very issues that needed to be resolved was that when there isn't a normal family dynamic, how can we share this period of time to best nurture the children? And by spotlighting the inconsistencies with the Constitution, the High Court has essentially called for change and emphasized equal recognition. And just to go to the last question as well, equal recognition and dignity and choice in parental roles, so that as the legal landscape shifts with this very issue of these traditional family roles versus untraditional family roles, it calls for the employers and companies to reevaluate and adopt a more inclusive and equitable modern understanding of parenthood. There's such a wide range and dynamic of types of parents and family relationships. So, in doing this, employers will be required to review and amend their leave policies in relation to parental or maternity leave that do at least allow for all of these untraditional family relationships, should we call it. And so in doing so, they would adopt a more flexible approach, which affords parents autonomy to decide on their leave division to accommodate for all of these things that we're foreseeing.
Are we likely to see a pushback from business, from employers, as I expect this will affect their operations? And I don't know if we spoke about this. With the 4 months leave, our companies then expected to pay their employees within that period. Are we likely to see litigation coming from the business side of things?
Look, it's very early days. It's quite difficult to tell at this point because, while the courts and allowing the empowerment of parents to sort of allow their leave distribution and how commendable it is going to introduce operational intricacies for employers that they're going to have to deal with. And so in amending these respective leave policies, employers will have to consider ensuring that these principles of proactive planning and open communication and reasonable flexibility as a result thereof are key and important in this case. So, for example, employees would be required to give in writing well in advance the manner in which they're going, the father and the mother or the partners or the parents would be sharing this period of leave. That would be in a policy, which of course would be a rule that you would have to abide by. And what this will do is it'll allow employers a lot of time to then prepare for those periods in which that employee may be off. And there's different ways in which we can do that. We can do that through employing other employees on fixed-term contracts, or the use of temporary employment services to fill those roles while the parents are on these periods of leave. But what's key is early and effective communication between the two parties. And what this will do is it will mitigate the very issues that you're speaking about and these operational intricacies that the employers at least are probably going to foresee. And speaking to that very issue of being paid, the Basic Conditions of Employment Act or no Act obligates an employer to pay for the period of maternity or parental leave. And so employees have the ability to go to the UIF and make claims from the UIF if they're contributors for that period. And as I spoke about employing someone else on a fixed-term contract or in temporary employment services, because they're not paying that employee, they can then pay for those services in order to mitigate those operational intricacies that the employers and the companies may face.
Very well, Dylan. Thank you so much for your insights. We certainly appreciate it, giving us a bit of clarity with regards to that law that now allows both parents to have at least 4 months of parental leave.